Everyone and welcome back to the channel. This is Snigdha Mohapatra, a third year student from KIT School of Law and currently an intern under LEXCLIQ. So the topic for today's video is contract of guarantee and concepts related to it. Now what is a contract of guarantee? It is basically a contract to perform the promise or discharge the liability of a third person in case of his default. A person who gives the guarantee is called a surety. Now, to understand the concept of guarantee, there are some other terms which needs to be understood first. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. A guarantee can be either oral or written. Now, what is a consideration for guarantee? Anything done or any promise made for the benefits of the principal debtor may be a sufficient consideration for the surety for giving the guarantee. Now, let me give you an example here. Suppose B requests A to sell and deliver to him goods on credit. A agrees to do so provided that C, a third person, will act as a surety and guarantee the payment of the price of the goods. C promises to act as a surety and guarantees the payment in consideration of A's promise to deliver the goods. Now, this is a sufficient consideration for C's promise. Now, another example is suppose A sells and delivers goods to B. C afterwards, without any consideration, agrees to pay for them in default of B. Now, in here, the agreement is basically void and there is no contract of guarantee. Now, what is a surety's liability? The liability of the surety is coextensive with that of the principal debtor unless it is otherwise provided by the contract. Now, this basically means that the surety has the same liabilities which the principal debtor has unless it has been otherwise mentioned in the contract. Now, next comes a continuing guarantee. A continuing guarantee is basically a guarantee which extends to a series of transactions. Suppose A, in consideration that B will employ C in collecting the rent of B's zamindari, promises B to be responsible to the amount of 5,000 rupees for the due collection and payment by C of those rents. Now, this is a continuing guarantee. Now, next comes revocation of continuing guarantee. A continuing guarantee may at any time be revoked by the surety as to future transactions by notice to the creditor. Next comes revocation of continuing guarantee by surety's death. The death of the surety operates in the absence of any contract to the contrary as a revocation of a continuing guarantee so far as regards future transactions. Now, discharge of duty by variance in terms of contract. Any variance made with the surety's consent in the terms of the contract between the principal debtor and the creditor discharges the surety as to the transaction subsequent to the variance. Now, the next concept is the discharge of surety by release of discharge of principal debtor. The surety is discharged by any contract between the creditor and the principal debtor by which the principal debtor is released or by any act or omission of the creditor, the legal consequence of which is the discharge of the principal debtor. For example, suppose A contracts with B to grow a crop of indigo on A's land and to deliver it to B at a fixed rate, and C guarantees A's performance of this contract. B diverts a stream of water which is necessary for irrigation of A's land and thereby prevents him from raising the indigo. C is no longer liable on his guarantee. Discharge of surety when creditor compounds with, gives time to, or agrees not to sue principal debtor. A contract when the creditor and the principal debtor by which the creditor makes a composition with or promises to give him to or not to sue the principal debtor discharges the surety unless the surety assents to such contract. Surety is not discharged when agreement made with third person to give them the give time to principal debtor, where a contract to give time to the principal debtor is made by the creditor with a third person and not with the principal debtor, the surety is not discharged. Now, another concept is the release of one co-surety does not discharge others. Where there are one or more sureties, who are known as co-sureties, a release by the creditor of one of them does not discharge the others. Neither does it free the surety so released from his responsibility to the other sureties. Another main concept under the contract of guarantee is that co-sureties are liable to contract equally. When there are two or more persons as co-sureties of the same debt or duty, either jointly or severally, and whether under the same or different contracts, and whether with or without the knowledge of each other, the co-sureties in the absence of any contract to the contrary are liable as between themselves to pay each an equal share of the whole debt or of that part of which remains unpaid by the principal debtor. Thank you so much for watching the video, and please subscribe to the channel for further and regular updates.